side has 15 minutes to present oral argument. The appellant will proceed first and may reserve up to 5 minutes for rebuttal. I will be keeping time so that if you will let me know if you wish to reserve any time, I will give you the signal as you approach that time. We've read the briefs and we're prepared to hear the argument.
Thank you, Your Honor. May it please the court, I will reserve. Sorry.
Yes.
As I said, please court, I will reserve 3 minutes for rebuttal. Your Honor, this is a case where initially there was a motion filed. Magistrate heard the case on a motion for reallocation of parental rights, made a decision, granted custody or residential parent status to the father. Mother filed objections to that decision based on the manifest weight of the evidence. Trial court found that the magistrate's decision was against the manifest weight of the evidence, and that's why we're here today. I have assigned 3 assignments of error. Actually, what I'd like to touch on initially is assignment number 3, just briefly. In fact, I'm going to touch briefly on all my assignments of error because I don't want to repeat what I've got in my briefs, as the courts indicated they've read them. And the appellee, in their response, they didn't really respond to my brief because there's a distinction between what I'm bringing to this court, and I want to bring that forward. There's a distinction between what I'm bringing to this court. I'm not arguing that the decision that the judge made, trial judge admitted, was against the weight of the evidence, because in essence, the decisions are pretty much mirroring each other. My argument is that trial court finding that the magistrate's original decision was against the manifest weight of the evidence. What the appellees got in their brief is more of a support of the trial court's decision. It doesn't argue against what I brought forth to this court. But assignment number 3 says a trial court erred as a matter of law and abuses discretion by failing to properly conduct the independent review of the magistrate's decision as required by Civil Rule 53D4B. What I want to point out there is, if the trial court had done what it was supposed to do and do this independent review, there's no way it could have come up with the actual decision it did, for the simple reason the court, if you look at the first line of its order, it says that the shared parenting plan is not terminated and mother is the residential parent. That's a legal inconsistency that can't exist. You can't have shared parenting and a sole residential parent. It doesn't say she's residential parent for school purposes. It says she's residential parent. So we're sitting on a conflict that's ultimately going to have to be probably reviewed again in that court. So I can't see that the trial court did what it was supposed to do in its independent review in that regard. Okay, I'm taking the court back now to assignment of error number 1. The trial court erred as a matter of law and abuses discretion in sustaining matters' objections by holding that the magistrate's decision was against the manifest weight of the evidence. As I indicated, the trial court reversed its decision, or the magistrate's decision, based solely on that one assignment of error. However, the trial court never laid out any reasoning how that was against the manifest weight of the evidence. Never said one word, simply, not one word of how the magistrate erred in her facts or how she abused the law in anything in its decision. It just says mother's objection is sustained. It didn't say that this fact is wrong, this fact is wrong, we interpret this fact differently, or any of that decision. So, I feel the court erred in abuse of trust in that fact. In my brief, I laid out an entire comparison. I did that in my brief in pages 10 through 13 of the trial court's decision and also the magistrate's decision. And if the court has read those briefs, it'll note that those decisions are basically mirrors of each other. The trial court pretty much said the same thing the magistrate did, so I don't see how she's saying there was a manifest, not a manifest weight, supporting the magistrate's decision when the court has made the same decision, except there's 2 points to be made. One is that the trial court found that mother was probably better for, it said, she demonstrated a greater commitment to Madeline's schooling. That was in her decision, the trial court decision. And there's no evidentiary proof of that. The only thing that supports that, and this trial court's decision has cites the transcript at page 17 and page 26. And if you look at those two references in the transcript, they're actually contrary to each other. The guardian ad litem says she saw that the grades were slightly improving, where Randy Flick, the court evaluator, made the comment that he sees issues with Madeline because of her grades. So those are two things that are totally different scenarios, and they don't support what the court has said about the schooling issue. Now, with manifest weight of the evidence, magistrate sat as the trier of fact. She's the one that saw the witnesses. She heard the witnesses. She judged the credibility of the witnesses. The trial court has failed to give the magistrate any deference in that respect. She was the one that sat there through all the evidence. She heard father. She heard mother. She heard the two, quote, experts, the guardian ad litem, the court evaluator. Trial court didn't hear any of this. And another point that I want to make out of all that is, the magistrate was the only one that did an in-camera interview. And the trial court totally brushes that past. Nowhere in this decision does the trial court mention the interview with the child, the in-camera by the magistrate. How could the court have done a full review and not even considered that fact? That has to be an important fact in the magistrate's decision, but it's not mentioned anywhere.
Well, the two quote-unquote
Sure.
experts that you indicate that the magistrate heard, both, as I recall from the briefs, recommended that mother be the residential parent.
For school purposes, that's correct.
Just for school purposes?
Yes,
Okay.
yes. They both recommended that the shared parenting plan stay in effect and whether it be residential parent or school purposes. I won't disagree with that. My second assignment of error was the fact that the trial court didn't have sufficiency of evidence to make the findings it did, basically, which, let's say, it trumped the magistrate's decision, because there's no other way of putting it, is, as I indicated, the decisions mirror each other. Paperwork bears that out. The only thing were the school decision, and the other decision was that father and mother have a conflict with visitation, that they both have a problem with this. Well, the evidence didn't support that father has ever had any kind of conflict or had any problems with giving mom visitation or with visitation, but there was evidence to the contrary where there's been mothers had a problem giving father visitation. So there wasn't evidence to support the findings of the trial court. I'm not saying, again, this is not a weight of the evidence argument against the trial court. What I'm saying is there was plenty of evidence there initially by the magistrate for that decision to be supported. There was competent, credible evidence there. There wasn't enough for the trial court to step in and say, magistrate, you're wrong. I'm taking this over. I'm giving custody to the mother. First of all, mother never even made a motion for custody. The only motion in this case was from father. So, in that instance, I believe the trial court also abuses discretion. I'll reserve the rest for.
Good morning, Madam Justices, my esteemed colleague, Mr. Sheenice. I'm somewhat confused by some of the points that were brought up, but I would like to address those if I may. What occurred here is what was supposed to occur. The perfect, successful checks and balances that should be occurring in our courts at all levels. We had a motion brought by father because mother gave a notice that she intended to relocate. And pursuant to the rules, father then filed a motion in opposition to that, asking for custody. As Mr. Sheenice does point out, there was an evidentiary hearing, the transcripts of which have been presented, of course, to this court for review, but also to Judge Quinn for review. All the evidence that was presented in front of the magistrate was also available and reviewed by the judge. Nothing more, nothing less. The magistrate heard 4 people testify, mother and father, both who have a dog in the fight, both who are subjective and will give testimony in the light most favorable to their position. That's understandable. So the other 2 individuals that presented evidence to the court were Randy Flick, who works for Family Court Services, and Dr. Elizabeth Holmes, the guardian ad litem, a child psychologist. She interviewed the minor child, as did Mr. Randy Flick. Both parties felt, for a myriad of reasons, that mother should be allowed to move and Madeline's school should be changed to mother's district.
Now that evidence was presented before the magistrate,
Yes, Your
the
Honor.
testimony of both the parties,
Yes,
as well as the quote-unquote experts.
Yes, Your Honor.
What you have not indicated is that when the magistrate initially ruled, the trial court adopted that as its order, and it was only after mother filed an objection that the trial court granted or sustained the objection. Am I correct in that?
Well, Your Honor, you have 14 days to object before they adopt it, and it was filed in a timely manner within the 14-day period.
But in the interim, did the trial court adopt the decision of the magistrate?
Not to my knowledge. And what I mean by that is, if they had adopted the decision, I would have been out of my 14-day time to file my objection. Of greater concern, and I think, to me, father being granted custody by the magistrate, and the magistrate requiring father to take parenting classes, is almost unheard of. And I believe the trial court, in its review of the magistrate's decision, looked at all the testimony, the transcripts. There was no actual documentary evidence produced at trial. It was all by testimony of the parents and or the guardian ad litem and Family Court Services. The child that is in question had many problems in school. School was a real problem. The transcript, the review of the transcript, it's well laid out that mother really was primarily the parent who was more involved with school, that mother was the one who made the child do homework, addressed the child's cleanliness, hygiene needs, this is nothing to impugn anything about father's abilities. In the magistrate's decision, in reading the magistrate's decision, based on everything that she stated, one would clearly state that mother should have been named the residential based on the evidence and testimony. And I think that's what the trial court, when reviewing, and when Mr. Sheenice says an independent review was not performed by Judge Quinn, I beg to differ. They read the transcripts, and there were no documents presented to the court to review other than the testimony of the parties. They also review Family Court Services file. Your Honors, Family Court Services and the guardian ad litem both submit reports. They are held in confidential files that are only for review of counsel and or a magistrate or the judge when making a determination. And those reports were clear that the shared parenting plan should remain in effect, that my client should be the residential parent for school purposes, and the reasons were very well laid out. And again, with Mr. Sheenice's argument, if we go to the argument that there wasn't sufficient evidence for the trial court to sustain my objection, I apologize. Judge Quinn had the exact same evidence that Magistrate Guy did. So the argument sounds to me that Magistrate Guy didn't have enough evidence to make a decision, if you go with that logic.
Well, except that the trial court did not have the benefit of having the witnesses testify live and observe the demeanor, et cetera, that the magistrate did.
And I appreciate that, but you know, Your Honor, this isn't about liking someone or disliking someone. It's not about what someone looks like. It's about what they say, and what they say, how it affects and impacts the case. I understand and I appreciate, and it is well settled, that the trier of fact truly does have that benefit. They have that leg up. They get to see the people, the interaction. And I believe that is important.
Well, I wonder how that relates to this whole issue of, that you've raised about father being, the magistrate ruling that father be the residential parent subject to his taking classes, and you indicate that, you know, that suggests that he really wasn't in a position and he needed help because mother was not ordered to take any kind of classes. But in the context of having a teenage daughter, it sounded to me as if the trial court was attempting to equip the father, as with many fathers, to deal with some of the issues that are raised in terms of hygiene, in terms of, you know, development of the daughter, and perhaps to facilitate communication on those issues, which I didn't see as a slam against father, as you have characterized it.
Well, I appreciate that, and I don't mean to make it sound as if it's a slam, but I'm sure, Your Honor, I know you read the transcripts. This is a child who has mental health issues.
Yes.
She has been bullied in school. She engages in self-injurious behavior. Parenting classes alone won't equip anyone to deal with those kinds of things that Madeline was facing at the time.
And there were some issues involving her communication with mother as well.
Well, and may I say, I'm sure that all teenagers have some communication problems with their parents. I believe that from the guardian ad litem's perspective, and since she's not here to correct me or whatever the case may be, I would say that she felt that mother would be the one that would be able to guide this child through the process that she was going through, because she had been dealing with it all along, and mom had a better understanding and a little more insight as to what was happening with Madeline at school.
What are we to do with the, and correct me if I'm wrong, if I've got the state of the record wrong, but with the fact that the magistrate did an in-camera interview with the child, but the trial court, in ruling on the objections, did not have the benefit of whatever occurred or having that in-camera contact with the child?
Well, Your Honor, several points. Number one, no one had the benefit of that in-camera interview. We were not present, obviously. There was no recording presented to myself or Mr. Sheenice. It was done after the trial. It was not done before. It was done afterwards. The guardian ad litem and Randy Flick both indicated in their reports that the child's wish was to live with dad. So I don't know if Judge Quinn would have gained any more insight whatsoever if he had done an in-camera interview of the minor child. Magistrate Guy did not reflect in her own finding any information that she gathered or garnered from that particular in-camera interview. So it was not, if she took that into consideration, Your Honors, it did not become a matter of the order. It was not present in the order. But she did indicate, as did the judge, they both accurately indicated what the child's wishes were. Going further, again, as I indicated, this is why parties have the opportunity to file an objection. If they feel that the information that was presented to the court ended up in a ruling that was contrary to the evidence presented, they have the right to take objection. The court then does an independent review. Quite frankly, I don't believe courts like to be in a position where they're at odds in their decisions. And I think there has to be a significant abuse or error or failure to weigh the evidence appropriately for the judges to sustain objections.
One would think that the trial court would point that out in the ruling on the objection, and as your counterpart has indicated, there's no reference to an error of law, there's no reference to disagreement as to the facts. What do we make of that?
Well, because they indicated, since I was not bringing that up until objection 2 and 3, they indicated because they sustained 1, then they found 2 and 3 to be moot. That's the way I would address that, but I've been on this side before myself. And when the system works, it's a beautiful thing. And one would hope that all the people that live in this country have the right to have their decisions reviewed and to make sure that the system did what it was supposed to do. And I do believe in, I've been doing this almost 26 years, and I've been doing domestic relations work primarily. It is seldom that objections are sustained. And when they are sustained, it's because, as Her Honor indicated, there's some glaring error of law, mistake of fact, abuse of discretion, or a decision that comes out that is against the manifest weight of the evidence presented. And in this particular case, taking the information garnered from Randy Flick from Family Court Services and the guardian ad litem, those two things standing by themselves, again, as I said, the parents gave their position in their testimony and their feelings and subjective ideas of what was happening. I think as you said, quote unquote professionals, but the only two objective parties that testified in this particular manner were very clear by applying, and the guardian ad litem applies the different standards, the same standards that the court does, as to what first would be in the best interest of this child. And I would say, quite frankly, Judge Quinn, after doing a thorough review of the record, any other evidence, came up with that same conclusion, that these two individuals did make a recommendation to this court that was ignored by the magistrate for whatever reason. And again, I hope it's not because of demeanor, how someone looks, who she likes or doesn't like.
Well, demeanor doesn't have anything to do with how a person looks or whether they like the person. It's a means of looking at the way that the individual testifies in order to determine credibility, not popularity.
I understand that, and I think what I'm suggesting to you, Your Honor, is sometimes there is a bias. There is a bias. I've encountered it, not frequently though, thank goodness, but it does happen.
Well, on that point, what specific evidence is there in this case of what you propose, that there is a bias?
I'm not suggesting to you, Your Honor, that I specifically can point to a bias. I cannot read the magistrate's mind. I can only say I sat through that three days that we were there, as did Mr. Sheenice, and the evidence was very clear as it was presented what the probable outcome would be, just based on the evidence and testimony, at least in my mind, and I've been wrong many times. I cannot pinpoint, I really couldn't even fathom how the decision came out the way that it did, based on sitting there and listening to the evidence.
And you've reached the end of your time.
And I thank you so very much.
Counsel, you have 5 minutes.
I just, actually, I want to go off of the last major point she made. Where is that glaring mistake of law, mistake of fact, or whatever the magistrate was supposed to have made, that she says it's needed to sustain an objection. It's not there. That was my whole point. What did the magistrate do wrong in this case? The magistrate sat there, the magistrate heard the evidence, the magistrate did the in-camera interview, and she did refer to it in her decision. The magistrate, she might have not stated what the child said to her, other than the fact the child did express her interest in staying in the Manchester School District. But what did she do wrong? Nothing. She did her job, and she made the decision. And the judge made basically the same decision. I didn't argue when I said sufficiency of evidence that the magistrate didn't have sufficiency of evidence. I pointed out initially that point. I made 2 points to this court in my brief that I didn't feel were the trial court had sufficiency of evidence. And I pointed out specific issues within the transcripts to support that. The ruling where the trial court had said about mother being more able with child schooling, take care of her, and the issues, the conflicts and visitation between the parties. Those are the only 2 things I pointed out that I felt there weren't sufficiency of evidence for the trial court to make a ruling on. The others were the same. Why would I say that the trial court didn't have sufficiency? I would be saying the magistrate didn't have sufficiency. I didn't say that. So that's a correction as to what counsel had said. Court addressed basically the same point I had made in my brief. This parenting class was nothing more than an aid to my client who was getting a teenage daughter for the first time, full time. He had her obviously on the weekends and during the week, but never full time. I think during the thing, it was brought out, I think the guardian ad litem said, well, they had never gone grocery shopping together, they had never done this, they had never done that. They labeled dad as the fun parent because when she was with dad, they went out and did things. But dad wasn't able to handle responsibility because dad had never did these things, whether grocery shopping, you know, the laundry, all these kind of things on a weekly basis. Well, the parenting class would have assisted him with it, doing these things. And the magistrate saw that in advance. And I applaud the magistrate for you doing that. And my client took that class immediately. It wasn't a punishment, or it wasn't saying you can't handle your daughter. It's saying, here, I'm giving you a tool to help your daughter. So in that respect, basically what the court said was the argument I presented in my brief. Counsel said within the transcripts there was a myriad of reasons that the guardian ad litem and Randy Flick said that mother should be the residential parent. If the court looks at those transcripts, looks at the briefs, I made the points. There is not a myriad of reasons. The testimony was not that long. There's very few specific points. Some of the points are conflicting. Father, Randy Flick even indicated he's got 2 kids, and sometimes mother's good for the child, sometimes father's good for the child. So there is not a myriad of reasons. And the point I want to make there is, if there was, it's not in her brief. It's just her making open-end statements. It's not anywhere in her briefs. Actually, that's all I have, Carla. I appreciate the court's time. Thank you.
Thank you both for your presentations. The court will take the matter under advisement, will issue an opinion, which will be sent to both parties, and do check this opinion